Thank you very much for persevering. What has been a very long day and 3 intense days of exchanging scholarship, discussion, and testimony about the Greek case and its legacy. I think it's been an important encounter between experts, scholars, and researchers across disciplines, but also activists, journalists, and political prisoners involved in the Greek case. And this counterpoint of different voices and perspectives was both crucial and productive, I think, supporting a kind of history telling that allows for voices of survivors and witnesses to be included in and shape the historical record in our own understanding of events such as this one. This multi-layered encounter also mirrors the different levels of synergies involved in the Greek case, essentially brought forward by the organizing of and collaboration between individuals, non-governmental organizations, and institutions. And I would like to emphasize the word organization here, something missing today in our political life as citizens, and which the Greek case calls us to rethink our position as active citizens and political subjects. That the Greek case was an act of international and institutional solidarity lacking ethnic and national interest is a point that was underlined and stressed by many people in the 3 days. It is a point pertinent to today's political landscape of violations of civil liberties and human rights and growing police brutality internationally, but also in Greece. And I'm thinking here of calls of adopting concentration camps for refugees as state policy, which we heard yesterday also by Professor Kjaersgaard, but also incidents of police brutality taking place not far from this hall, sadly not sparking the needed political discussion one would anticipate. Before giving the floor to the others, I would also like to flag 2 points that I thought were very interesting to me. First, how the Greek case transformed the young Amnesty International from an organization supporting individual cases of prisoners calling for amnesty to an international organization that investigates torture as a state practice, relying to the creation and input of active local branches. And second, I would also like to note the dichotomy that I think Professor Kjaersgaard also noted between torture and cruel, inhuman, and degrading treatment, and the way torture was placed in these early intrastate cases at the high end of the scale, even though both torture and CAD are equally condemned by Article 3. This is a dichotomy that has had implications for the technologies of terror developing in this period and has allowed states to use torture in ways that evade international law. Periklis Korovesis noted how torture was practiced before, during, and after the junta, even today, and he's right. What I think this conference also underlines is our ethical responsibility to find ways of exposing these methods and these stories otherwise silenced through our research and scholarship, but also through organized activism and alliances across institutions and collectivities. Despite their weaknesses, flaws, and limitations, institutions and laws are there and need to be reclaimed and re-energized. And on this note, I will give the floor to Steve.
Thank you very much. Can you all hear me? Yes, we can, I think. Many of the panelists, of the panelists have been thanking the organizers, and I would like to begin by thanking all the participants, the panelists, the testimonies, the audience broadly for taking part in this conference and enlightening me as a researcher in various ways on this topic of the Greek case, which I actually thought I knew fairly well. But I think this 3-day conference has really been enlightening, and it has been very fruitful to have both the academic papers and more personal, private stories of individual actors and of all the testimonies. So I think in general it has been a really good combination of various voices within this, or speaking to this Greek case in various ways. I was thinking of of how to conclude these concluding remarks. And what I will be doing is that I will try to perceive of this conference as a state of the art. What is the status of research with regard to the Greek case as it is now, based on all the papers and the testimonies, the questions from the audience in general, and I should probably admit that I'm mostly qualified to conclude or to summarize the debate with regard to historical research, less with regard to all the legal contributions. I think it's very relevant that we have been approaching the Greek case from a variety of perspectives. We have been looking at what is very often discussed in historical research, at least, who have been the key actors, state actors, non-state actors, and with regard to state actors, smaller states, the applicant states, the Scandinavian states and the Netherlands, also larger West European states, Germany, Spain, Italy, international organizations, even the Council of Europe, of course, but also the European communities have formed part of the actors which have had an impact on the development and the legacy, the later impact of the Greek case. Within research, this is very often almost about to say a contentious debate, discussing the hierarchy between these various actors and the impact that they have arguably had. We have not really had a debate on which actors have been the most important here. Research will continue to do so, but I think one of the qualities with this conference has been that we have really been able to paint a broader picture of the interrelationship and interdependencies between these various actors. How have the institutional setup of the Council of Europe framed what various states could do within the Council, and what has also been the relationship between non-state actors, lobbyists, private individuals, NGOs, in relation to the way in which various states have acted, both with regard to pursuing this application or submitting the application, but also the way in which various states, the Scandinavian states perhaps in particular, have pursued the case within the Council of Europe and so on, or during the case, so to say. So I think we have painted this broader picture here, but I think in research we will probably still continue to address the question of which actors have been the most important. So we have been kind of a consensus and less of a debate concerning that issue here. Perhaps we have settled it. And I would not begin to take way too long to enter or to propose a response to the way in which the interrelationship and interdependencies between these various actors have been. But I think this is one thing that we have had this consensus, but I think also it's relevant to continue a debate, a research debate on the way in which these actors have interacted. I would like to point to one more thing that has been mentioned, or topic that has been mentioned, not least with regard to the Scandinavian states. At least I had the impression that several of the papers argued in particular that it was a social democratic ideology or idea behind the application, which I will not question, but I would like to add though, and it was also mentioned in the Danish case by our first keynote speaker, Professor Pelt, that the social democratic policy was pursued or taken over by the Liberal government later on. Just one note to that I think it is not to talk more about Denmark, but I think it's relevant in order to, which is also a thing one may continue to discuss, whether this is a social democratic endeavor or whether it is actually a broader cross-party political consensus. I remember, and this is relevant in relation to a question, I remember on the first day whether there was a contradiction, dichotomy between the state level and the people within the Commission, for instance. And now comes the point. The Danish Commissioner or during the Greek case, Mark Sørensen was his name. He was actually more a pragmatist and less of an idealist compared to this liberal foreign minister who continued the social democratic policy when Denmark submitted the application, because Mark Sørensen would actually favor a friendly settlement, and this was in opposition to what the foreign minister would argue. So cross-party agreement or consensus in Denmark at least, and I think it is, no, I should not go into that for the other countries, but I think that it is important to question whether it was social democracy alone or a broader consensus, and I think also it's relevant to point to or a footnote to answer one of the questions on the first day, that there were, at least in the Danish case, a discussion between the political level and the level of participants in the Commission. And I will try to be brief. How many minutes do I have left? 2?
I'm not counting.
You're not counting. Okay.
2 minutes. I trust everybody here.
I said that before, that my impression is that there has been much consensus within the discussions that we've had here in general with regard to central state actors, for instance. What there has perhaps been less consensus about is or at least where the interpretations have been more of say, I think the term was used of a negative kind, was with regard to the efficiency of the Council of Europe, the European human rights system, which I will not dwell much on, but I think it's relevant in relation to the assessment of the legacy of the Greek case, because if there is some limits, or have been some limits to the efficiency of the Council of Europe due to this inbuilt dichotomy or dilemma between a human rights norm and the principle of national sovereignty, then it is perhaps even more noticeable how effectful, or the legacy, the positive legacy that the Greek case has had. 2 more things, briefly. We have been emphasizing the Greek case here. Of course, this is the theme of the conference. At the same time, I try to remind myself, to put it that way, that we should remember not to overestimate the topic we're focusing on. Which contradicts with what I just said, that the impact of the Greek case is even more important if we can subscribe to this critical assessment of the efficiency of the Council of Europe, of the European human rights system. But if we should, which I think this reminder to myself not to emphasize the field that I'm working with, if we should try to assess the impact of the Greek case from a historical perspective or historical scholar perspective, this could be done by linking what we have been talking about here, the impact of the Greek case, to a broader literature of the impact of, or the discussion on the breakthrough of international human rights, which is in short divided into the Enlightenment period, the 1940s, the 1970s, and perhaps the 1960s. So, and this would suit well with the argument for the 1960s. But I'll just remind myself of this because there is a discussion, or it will place the impact of the Greek case, I think, in context. There are other periods, decades, points of time of breakthrough, which we should perhaps discuss the impact of the Greek case in relation to. And we may also enter into discussions of how do we at all define breakthrough, etc. The very last thing, the title of the conference has been the Greek case in the Council of Europe, a game changer for international law and human rights. So I may not be the only one, but I'm asking myself, well, and we have been going into various ways in which the Greek case has been a game changer. But it also, I think, gave me the occasion to consider, well, how exactly is it that we study historical change related to not overemphasizing the topic that we are working with. What does it take for a case to be a game changer? Which game is it exactly that is being changed? And I'm not questioning any of the positive impact that the Greek case has obviously had, but and I will not go into discussing how to study historical change. It has to do with, of course, looking what came before and what came after. And I think what also made me think of this question was the second keynote speaker, Papaeti, if she's still here, who actually went back 10 years prior to our Greek case and looked at this case of Greece versus the UK with regard to Cyprus, arguing that there were, dare not to say breakthrough, but there was a beginning, at least, if I understood you correctly, of how to define torture 10 years ago. So just to put our topic of research and the topic for our 3-day conference here a bit in context with regard to this overall debate on the breakthrough of human rights. Should we study this by looking at pivotal cases, pivotal points in history, or should we rather consider those cases as steps on throughout the historical process? So just some questions at least that this conference also made me think of, perhaps only me. Thank you.
Thank you.
Okay, so in my view, this conference tried to do many things, apart from the interdisciplinarity that was mentioned by Anna and Kristine, putting historians, legal experts, and testimonies together. We tried to look at both the inside of Greece and outside of Greece at the time of the Greek case, the history of states as actors, but also institutions as actors, versus the history of everyday people, ordinary people very often, who were tortured or witnessing torture. And it also tried to look at what we could call the meso level between the two. So mainly all these transnational advocacy networks that were organized and operated in an incredible way. We had of legal specialists, lawyers, becoming a very important category of actors. Now, in terms of Scandinavian countries, the Netherlands, but also the social movements and the solidarity movements in West Germany and elsewhere, I think a very important issue that came up was not just this battle between pragmatism and idealism that Kristine mentioned, but also the genealogies. Genealogies that often date back to the 1940s. We heard about the rise of Holocaust consciousness in West Germany, and not only in West Germany. The history of colonialism in Holland or elsewhere, and the connected colonial guilt as providing the background for this human rights boom. We see in other words how these movements, but also the institutions that we talk about in Western Europe, were motivated by historical traditions and political landscapes far from Greece. But you know that also Barbara Keys has showed this, that you know, the cross-national trends were shaped very often by local realms. And in general, the inside-outside issue, I think, was a very recurrent one throughout the conference, including how the countries that became watchdogs of human rights elsewhere applied these very human rights at home in terms of domestic legal order. Another question that arose was whether this moral investment in the Greek case was in fact the outcome of looking at Greece as the cradle of democracy, now having fallen prey to barbarism that motivated all these countries? Or was it the interstate relations prior to 1967, as we had by Montspel in second keynote, and individual countries' interest in Greece, like Denmark's, even before the coup, was that a catalyst? Or was it rather the third worldization of Greece, the fact that Greece was seen as the new Vietnam, a European Vietnam, a neo-colonial situation of sorts that was utterly unacceptable? I think what came out was that it is of crucial importance to think of all these symbolic geographies in place and maybe their interplay. Amnesty International's role was very important, as we heard, precisely because it tried to supersede the Cold War binary, looking at human rights abuses on both sides of the so-called Iron Curtain. The fact that the issue of human rights, for example, was very often in Western countries, at least the language used by communist parties and groupings and sympathizers since the end of the Second World War started to change in the late 60s. But an important question that came up in many panels was whether solidarity movements castigating human rights violations in colonial Greece were in fact left-wing, and how could revolutionary goals and human rights go hand in hand? This was an issue that became a big part, I think, of human rights debates in the following decade, so especially in the late 70s, with controversial philosophers, people like André Glusman and Bernard Henri, especially in France, spearheading this trend of accusing the left, of which they came from, of turning a blind eye to human rights abuses in the East. So the uneasy alliance between left-wingers, social democrats and liberals, brought together by the 1960s movements and issues like the Greek junta and the Greek case that we saw, collapsed in the 1970s precisely on this ground, and with the rise of the category of dissidents in Eastern Europe. Maybe in a way the root of that latter conundrum lies already in the late 60s developments that we have been discussing, and the very consolidation of the notion of human rights. I kept thinking also about the impact of structures, but vis-a-vis the impact of agency. In terms of institutions, we heard about the importance of going back to the 50s and decolonization. Interestingly, in Barbara Key's keynote speech on Cyprus, as part of a general genealogy of how torture alone became the test of certain core values, placing it so above of inhuman treatment. On the other hand, in terms of international institutions, not all stories that we had were rosy. So we had of the Red Cross, Mr. Notaras, in his testimony, for example, he talked about the historical itinerary of the Red Cross since the Second World War as not being a very positive one. James Beckett himself, I think, noticed in his writings how skeptical and unresponsive the International Committee of the Red Cross had been back in 1967 during his own investigation with Morocco in Greece. I thought about the interaction between the macro and the micro, so again, how the big institutions, including the Council of Europe and its organs, interacted with ordinary people who had been tortured, who went there to testify. I thought of Kitty Arseni's testimony, where she talks about the fact that in her writings, she reflects about how difficult it was for her to testify in extremely clinical at times, terrifying in a way for her terms. She had to show her physical scars in front of an international committee in Strasbourg. Today's testimonies made me think of that, of how trauma was eventually turned into narrative, but narrativization is not easy, and there is of course a certain unspeakability of terror, and I was wondering how difficult it must have been to make evidence out of torture and terror, and how tough it still is to talk about it 50 years later for the people in question, and also especially when gender adds up to the equation. Now, in terms of agency, it has been repeated many times that personalities made a difference, like Peter Loikrecht, Max van der Stoel, in terms of politicians or intellectuals and well-known artists or activists, Maria Fleming, Melina Mercouri, Maria Beckett, who made a difference. I was wondering, to what extent this kind of political engagement would be possible today on all fronts, because I doubt that there are no charismatic personalities around that. And, you know, charismatic personalities always existed and always will exist. However, I'm not sure if the moral responsibility issue that connected global issues in the past, ranging from decolonization, Vietnam, the national liberation struggles in the so-called Third World, is present today. There was an interesting confluence at the time, relativizing the distances, creating the feeling that the global affected you locally, and that silence equated with complicity, which is, I think, at the core of the Greek case. So the last binary, of course, is the then and the now. So we heard how this conflict was no longer purely a political conflict, how it became legalized. On the other hand, it also became clear how law became politicized, as I think Kristine said. There is a very apparent contrast between then and now in today's apparent lack of combined efforts from the Council of Europe member states to push for the implementation of the European Convention, as Professor Vendek said in his keynote. But of course, once again, it is a different context from then, from the Cold War, and I guess it's up to legal experts like Vassilis to talk about this.
Okay, thank you very much. It's a tradition to start by thanking people involved in a conference. I'll do this, but before that, let me start in an unconventional way with a mea culpa. Not in the Papandreou way, possibly. But, and mea culpa is that the organizers, after 2.5 really long days, we're finishing with a lawyer. And verbosity, as you know, is a common feature of lawyers, so with your permission, my 60 minutes are starting. Let me start by thanking people. First of all, this wouldn't be possible without the administrative support we had from various institutions and people who are in this room, including Kostis. Kostis, thank you so much.
Yeah.
This is Then it is, of course, the institutions who organized this and divided us as members of the scientific committee to contribute. The members of the scientific committee, because we worked really well between us. Then I would like to somehow escalate this. And for me, it would be also two more type of actors that I would like to thank here, personally, on a personal note here. The first is as a Greek of the so-called Erasmus generation. I would like to thank the 4 African countries, because without them this wouldn't have been possible. And I'm not only referring to the conference and us sitting here discussing, but also the impact that this case had, etc., etc. For me, it is, again, I'm becoming personal here, it's very important. The second thing, and this is a lesson I learned also from this conference, I'll come back to it in a minute, is all the, let's call them the Beckets. I know that it is not fair to, all other, it could be the Sprouse, and it could be, many names, but the Beckets and their impact and how they took personal risks, they left aside self-interest, and they got involved in something that, we all benefited from it. So this is very important, and thank you very much and very honestly, and you can applaud here. I have 4 points to make. 2 of them concern the Greek case as such, I would say per se, but it's a Latin phrase, I will avoid it, another characteristic of lawyers. And 2, that it's perspective, it's for the future, and the legacy and how this can be used for the future. But before that, another preliminary point, which is, when I was invited to contribute to this, I must admit I was a bit skeptical, because lawyers and historians and different languages, different methods, I didn't know how it would work. And from my perspective, as a core lawyer, I learned a lot. And this is important, first of all, because you have a lawyer telling you he learned. You can recognize that we all wear a tie, have our business cards, and we use Latin phrases such as ergo, this code, and so we already know a lot. But learning more and admitting this openly is already. So I learned a lot, because for me, and we've all read the Greek case here, for me, you're watching a movie, okay, and you have a narration there, you have all the facts, and it is a fact-finding committee. And then the technical part, from my perspective, is coming, and we're discussing Article 15, and we're discussing what is torture, is the standards for Article 3, etc. So I have kind of technical and dry eye. And when we read these cases, sometimes we forget the story behind them. So for the metaphor to work here, for me this would be the making of this video, this movie of the Greek case. So I could see all the contributors, how we ended up with this story, and I can see behind the scenes what was happening. And in a sense, this is eye-opening, and this is what I personally gained from this story. And thank you very much, especially you, Kostis, for engaging with it. So my 4 points, and then my 60 minutes start counting now. No, it will not take a lot. Yeah, I know. So first question: what may? And I'll try to, not. I will not speak as a lawyer here. No technical language at all. So, what makes this Greek case possible? Why it happened? This is an important question, both for lawyers, but also for historians, etc. And this is, we've heard of different factors which are interconnected. I'm not sure I got a clear picture, but I'm confident. So, for instance, it has been mentioned that there can be a connection between the royal families, a nice hypothesis, etc. But I'm convinced, and this is one message from this conference, that this wouldn't happen without activism, without internationalization, without the networks that were built and that supported this. And this is one important message. But I was wondering whether we are missing something here. And this goes back to generational replacement and me feeling as part of this so-called Erasmus generation. And I prefer to link this conference with the prequel. So we had a series of events organized by the Institute in the previous month before the conference. And I think it was a Danish institute in April, but I will mispronounce the name. It was Paul Schmidt, was it? So a Danish journalist and activist who was heavily involved in the Greek case. And for me, it was really interesting to see the enthusiasm of that person. And one of the questions was asked to him, why you were involved, and this is the previous generation, they experienced the war. They know why the Council of Europe was made. They know that this is one of the two, ways to respond to war, to avoid having these atrocities again. So the mission of the Council of Europe is very clear in the mind of those people. And maybe in my generation, and we're now facing liberal democracies, and I'll come back to it, so it's a prospective part, we do not have the same, we take it for granted. This is, I never experienced a dictatorship, I never experienced war, I don't know what it is. I am listening about it, I'm reading in the news, etc., but I've never experienced it. So maybe I don't feel that it is my responsibility. I'm not in person, but my generation maybe. So this would be one question to leave you with. The second question, and this refers to something that an argument that I was afraid that I would listen to, being mentioned in this room, but it wasn't. I'm very happy for it. So the second question, was it worth it? This is a decision of a quasi-judicial body, 4 volumes long. No one would really read it. It was censorship to some extent. Maybe it was slightly liberalized after the release of this, but still, and it didn't end dictatorship. So I was afraid that someone would say, well, why were we doing all this? The dictatorship was still on. We kept having the same situation for a number of years, and then what is the value of all this? And of course there is value, and there are different dimensions. One of them, and again we're going back to the dry, perspective of the lawyer, and we've heard of different dimensions. How important this has been for the Council of Europe and the building then of different mechanisms within the Council of Europe. How important this has been for human rights and the idea of collective enforcement, removing injury from state responsibility, etc., etc. How important this has been for public international law, and how exceptional this case is. There are more examples maybe before the ACJ than what were mentioned, but I will not get into the technicalities here. So we've heard the importance of this case from a more technical and dry perspective. We've also heard a number of accounts or speculations maybe as to why this has been important during the dictatorship, what it meant to people, if it had an impact, to what extent it had an impact, etc. But for me, again, and this is another message, for me, it's two different things. The first thing is that it is a precedent. and present. We wouldn't be sitting here, we wouldn't be discussing this. It is there. It happened thanks to people who are in this room, thanks to this institution. It helped the institution evolving, and it is there. It set a paradigm, and we have it, and we will use it for the future. This is one thing. On the other hand, we must be realistic, and I know that I don't make any favor to my profession, but law is a tool. We cannot expect, you know, an institution like this to beat a dictatorship. On the one hand, you have the army. On the other hand, you have a legal document. Okay, it doesn't work, and I could give more examples. So I was among one of the people who were very happy with, you know, the case law of the European Court of Human Rights against the Cyprus case, against the Turkey for the Cyprus issue, and I was saying that, you know, many litigations will solve the Cyprus issue this way. It didn't work. You cannot remove an army by means of a judicial decision. The more cases you have, I mean, it's a big question there. You know, maybe that it didn't make good, you know, the standards, or you know, it's a big so wrong strategy. But it is important. It is important to have this precedent, not only from a legal perspective. Now, perspective as to the future. Two more questions. Illiberal democracies. Okay, so is the Greek case something that we can use as a tool for nowadays situations? Yes and no. I mean, first of all, the analogy is not perfect, and it is not perfect for reasons that have been mentioned. The first one is we do not. One is a dictatorship, a clear-cut situation. The other one is something which is in the gray zone. Okay. You have governments which are elected, and they draw legitimacy from, you know, popular vote in order to do what they do: academic freedom, judicial impartiality, etc., etc. The second reason why the analogy is not perfect is because now individual application is the standard tool, is the standard avenue. And this makes a big difference compared to the Greek case, because at that time this was the only remedy, this was the only avenue, and this is what made so important a condition for this to exist, the involvement of other states. But now we do not need this, and therefore what I would say is, again, let's be realistic, law is a tool. You cannot expect a court decision to change the world to the extent that we would like it to change. But on the other hand, let the institutions do their job, and they will produce. They have already started producing case law. I could refer to, you know, a former judge of the European Court of Human Rights who went before the European Court of Human Rights for judicial impartiality before his own country, which is one of the, you know, so-called liberal democracies, etc. So let the court do its, and all other institutions within the Council of Europe do their job. They will produce an acquis. They will produce materials that then will have some sort of impact, okay? And sanctioning case states, I already referred to it in one of the previous interventions. I will not elaborate on this. Obviously, there is a trade-off, okay? And there is a very fine balance that should be maintained, in the sense that you do not want to overdo it. At least this is my understanding, in the sense that you want states to be engaged, that you want them to be part of the system, so that individuals can apply, so that you can apply this kind of monitoring, you can apply that kind of soft power and pressure, etc. On the other hand, you do not want to give the wrong message that, you know, we will continue as nothing happened, and that you do not comply, you don't do anything. Then, and in that case, maybe we can differentiate it between states. One, again, needs to be realistic. The Russian Federation has been mentioned. This created problems to the Council of Europe. They contribute to the budget. Then, you know, again, I wouldn't want to become that political in that respect. My final point, and this is something going back to the discussions we had as an organizing committee. This might be a question also for political scientists, employing different methods. For instance, I would like to mention Kjaersgaard is someone who was involved. We were discussing him. He was involved in the resistance against. He's a political scientist. He's doing game theory. He might have the tools to give an answer, a clear answer, as to when, under which conditions. They have an algorithm. It's math, and they will tell us when exactly and when we should. I mean, under which conditions, what are the goals, and how we will achieve them. But this is a big question, And the Greek case, I'm not sure that in that respect it can be a precedent. Thank you very much.
Before closing, I would like to thank our dear friend, or we would like to thank our dear friend and colleague Willem Nederboer from the Dutch Institute, who has been the heart of this conference and has followed every little part of the organization and has been very patient with us on many occasions. So thank you very much, Willem. So thank you very much.